I would like to say a few words about the proposed Anti-Counterfeiting Trade Agreement, more commonly known as ACTA. The negotiating parties to this agreement include the European Union and the US and other developed countries, as well as a number of emerging economies. The basic aim of the ACTA is to establish effective enforcement standards for existing intellectual property rights. In this regard, it should be borne in mind that from an EU perspective, intellectual property rights account for a large proportion of the EU's GDP and are important to high-growth sectors. The EU can only remain competitive if it can rely on innovation, creativity, quality and brand exclusivity. These are some of the EU's main comparative advantages on the world market, and intellectual property rights protect them all. However, the means of adequately enforcing these rights in important export markets to date have been very limited. The agreement aims to establish a comprehensive international framework that will assist its members to effectively combat an infringement of IPRs. It will not create new IP rights, nor will it define their acquisition, duration, scope of protection or registration. ACTA countries will enforce the rights as they are defined domestically. It will encompass a range of provisions on the enforcement of intellectual property rights, including civil and criminal measures, customs measures, internet enforcement measures, as well as robust cooperation mechanisms among ACTA parties to assist in their enforcement efforts. Following 11 rounds of international negotiations over 2.5 years, a substantial level of agreement has been reached, and almost all outstanding issues have been resolved. While some further work needs to be completed, I expect the deal will be finalised in the very near future. Let me say a few words about the enforcement of IP legislation here in Ireland. As members of the House will be aware, the Minister for Justice and Law Reform is preparing a white paper on crime. In this regard, a number of discussion documents have been prepared, the most recent of which deals with organised and white-collar crime. The discussion paper contains a section on intellectual property crime and points to the active role played by Garda Síochána and the Revenue's Customs Service in ensuring effective enforcement of the legislation. And Garda Síochána has adopted a proactive approach in tackling IP enforcement issues, with the National Bureau of Criminal Investigation established as a response to organised crime. The anti-racketeering unit within the National Bureau of Criminal Investigation provides expert guidance and support to divisional and district Garda personnel tasked with investigating the importation and sale of illicit and counterfeit goods, including cigarettes. The sale of goods at markets is the subject of regular and ongoing monitoring by the Garda Síochána for counterfeit goods and products. The Revenue's Customs Service enforcement has concentrated mainly on the points of importation into the state and resulted in the seizure of growing quantities and varieties of products. In 2009, there were 1,019 intellectual property rights seizures valued at €2.5 million, in addition to the seizure of 116 million counterfeit cigarettes. In recent decades, due to the global nature of trade and the advent of internet trading, the need for global IP protection was identified. The World Intellectual Property Organization, WIPO, was established in 1967 to promote the protection of intellectual property throughout the world. WIPO develops conventions, treaties and other regulations on intellectual property protection through cooperation amongst member states and in collaboration with other international organisations. The most important single source of rulemaking in IP is now the European Union. Many of the provisions included in Irish primary and secondary legislation are in transposition of EU directives on intellectual property into Irish or domestic law. The Commission's work over the years in harmonising and coordinating national approaches in the IP field has had a powerful effect in creating and securing the benefits for all member states in the internal market. New issues and proposals continue to surface. At the present time, several significant Commission proposals are under active negotiation. One of these is the proposed EU patent. Unfortunately, the current European patent system, which is administered by the European Patents Office, is expensive and complex, particularly its translation requirements. After grant, the applicant must validate the patent in each country designated in which protection is required. This can be very laborious and expensive. It can also lead to legal uncertainty because if a patent is infringed, the patent holder must initiate legal proceedings in each individual country, with often different legal outcomes. Today, obtaining a patent in Europe costs 10 times more than securing one in the United States. In April 2007, the European Commission put forward a communication to the Council entitled Enhancing the Patent System in Europe. The Commission set out to get agreement on creating a simple, cost-effective and high-quality one-stop shop patent system in Europe, both for examination and grant, as well as post-grant procedures, including litigation. Negotiations on a future European Union patent are at an advanced stage. The proposed EU patent would provide protection covering all EU member states and substantially reduce costs to the industry. Ireland has long supported the proposed European Union patent as a way of encouraging competitiveness, innovation and reducing costs, especially for small to medium-sized companies. Another important area in the protection of intellectual property is that of copyright. The principal European directive in the area of copyright, the Copyright in the Information Society Directive of 2001, essentially harmonised the right of reproduction, the right of communication to the public, the right of making available to the public, and the distribution right. The basic principle underlying the harmonisation effort was to provide the rights holders with a high level of protection, and accordingly the scope of exclusive rights was very broadly defined at that time. In their 2009 Green Paper on Copyright, entitled Copyright in the Knowledge Economy, the European Commission pointed out that copyright laws have traditionally attempted to strike a balance between ensuring a reward for past creation and investment and future dissemination of knowledge products by introducing a list of exceptions and limitations to allow for certain specific activities which are usually regarded as desirable or in the public interest. These generally pertain to areas such as academic and scientific research, the activities of libraries and archives, and the rights of disabled people. The Commission considered that the main conclusion from the debate was that copyright policy must be geared towards meeting the challenges of the internet-based knowledge economy. They prioritised access to information products for people with disabilities, licensing solutions for mass-scale digitisation in a European context, and an impact assessment on how to foster the clearance issues that arise in the case of orphan works. The most recent European Economic Initiative, the Single Market Act, which is designed to achieve a competitive social market economy, underlines that the absence of a European framework for the efficient management of copyright across the European Union is significantly complicating the process of making knowledge and cultural goods available online. In order to create a single European digital market, the potential of online distribution must be used effectively by enhancing the availability of creative content, while at the same time ensuring that right holders obtain adequate remuneration and protection for their works. Accordingly, the Commission has stated that they will now be submitting a proposal for a framework directive on the management of copyright with the aim of opening up access to online content by improving the governance, transparency and electronic management of copyright. They will also next year be proposing a directive on the issue of orphan works. At the same time, there are those who advocate a more American approach to the issue of copyright on this side of the Atlantic. These advocates feel that a broader approach should be adopted in relation to exceptions and exemptions from copyright. They argue that digital innovators in the United States have benefited from the more flexible regime there of exceptions to copyright rules under the broad heading of fair use. They contrast this fair use clause, if you like, with what they categorise as Europe's catalogue of precisely defined exceptions which they feel are too inflexible to accommodate technological, business and broader societal developments. They consider that this prescriptive approach appears increasingly maladapted to the digital economy and that it deprives EU-based innovators of the flexibility that has stimulated the growth of high-tech businesses in the United States. This idea, which is being strongly propounded by the information and communications technology sector in Ireland, will also have to be taken into account and examined carefully in the context of any changes being contemplated in the area of copyright legislation in the future. Finally, Cathaoirleach, I'd like to thank you for providing me with this opportunity to address the Seanad on such an important topic. In outlining the importance of intellectual property to business and to innovation, I hope I've reassured the Seanad that the Government and I, as the responsible Minister, recognise that protection of intellectual property is a key factor in developing the smart economy. Protection of intellectual property is high on the priority list of the European Union also, and that is why there are so many initiatives under discussion in regard to intellectual property protection and the fight against counterfeiting and piracy. This Government is continually committed to fostering an environment which will continue to help Irish-based business, companies and industry to reap the benefits of investment, research, innovation, creativity and entrepreneurship, which are the building blocks of the Smart Economy plan and will pave the way to renewed growth in the Irish economy and a way out of this dreadful recession.
Thank you, Minister. Senator Cannon.
I'd like to welcome Minister Linehan to the Chamber. Intellectual property issues are getting more and more attention these days, and unfortunately far too often the issues are framed in such a way as to highlight controversy and indeed polarised debate. In fact, there is much about intellectual property protection on which most of us can agree. To arrive at a fuller understanding of the issue, it is worth spending some time considering how intellectual property rights developed and what role they play in achieving widely shared objectives. What comes out of any such examination is the conclusion that intellectual property is a vital part of social, cultural and economic development. Protection of intellectual property rights alone will not necessarily bring about this development, but it's hard to imagine any country could ever reach these goals in the absence of such protection. And the essential idea behind the copyright is fairly simple. Artists and creators should be able to enjoy the fruits of their labour for a specified time period, after which the material becomes available for public use. Society benefits because this incentive to create will yield a rich and varied cultural menu for its citizens. Indeed, one can say that copyright protection is a necessary ingredient for ensuring cultural wealth in our societies. But if copyright protection is important for reaching cultural objectives, then it is equally true that the theft of these copyrighted goods, that is the pirating of cultural works, is a threat to the creative sectors in our societies. And whilst there's been much press play recently regarding online downloading of music and movies in developed countries, in fact, it is in the developing world that much of the serious damage is being done. Many new musical voices, new authors and new stories on film around the world have never been made available simply because the incentives were not there for these artists to take a risk. They have known that whatever they produce would immediately be pirated, stolen, and they will not be provided the means to develop their talent. And this is not some sort of an abstract argument. It has happened on all continents. A good example is Hong Kong, where a thriving movie industry was so hurt by rampant piracy that just a few years ago observers were predicting it would disappear completely from the filmmaking map. Today, the industry in Hong Kong is in better shape and moviegoers around the world enjoy new and exciting releases primarily because Hong Kong authorities took very, very decisive action to combat the piracy problem in their own jurisdiction. Studios in Bangladesh's movie industry went on strike in March of 2004 to protest the problem of piracy and demand action by their own government. And similar developments have taken place in the world of music. Ethiopian musicians went on a 7-month strike in 2003 to press for better anti-piracy measures from the government. And all of these artists, in all of these different jurisdictions, they understood the importance of protecting their work from pirates. Here in Ireland, we've earned ourselves a reputation internationally as being an island of creativity, an island that has produced some of the world's finest music and literature. And for a small island of 4 million people, we are unique, I would believe, in having groups like the Chieftains, U2, the Corrs, the Cranberries, and more recently the Script, dominating the world music stage. Consequently, we need to ensure that the intellectual property rights of these artists, and indeed all of our artists, and also our innovators, are protected by law.